Sexual harassment. Unfortunately, it happens. Happens in the workplace, sometimes happens in the classroom or in and about school property. Well, that's one of the reasons Title IX came into existence, a federal law that prevents sexual discrimination. It also provides relief to someone who has been subject to sexual harassment and allows them to get reimbursement from the school district for the harms and injuries they suffer as a result of the sexual harassment. But before someone can bring a claim against a school district, they must give notice of this alleged act of sexual harassment. Well, that brings us to this week's case. Involves a young lady in Florida. She was concerned with what she viewed as sexual harassment by a math teacher. And she brought suit through her parents against the school district. School district said, hey, you never advised us of this. We never had any notice of this. You never told us about these alleged acts of sexual harassment. You just bring the suit, and because you just bring the suit, you did not do what you initially needed to do. You didn't give notice, and therefore, we are not liable. Well, the attorneys who represented this young lady were doing some research, found out that this math teacher who was accused of the sexual harassment had been involved in 2 other incidents, at least alleged incidents, and that the 2 other females had given notice to the principal of the school. Notice to the principal is notice to the school district. Therefore, they argued that there was notice to the school district and the suit could go forward. Well, the case went up on appeal. And on appeal, before a U.S. District Court of Appeals, it was found that indeed, notice had been given to the school district by virtue of the fact that these other 2 gals who had said we were being subjected to sexual harassment had placed them on notice of conduct by the same school teacher. And even though the woman, the young lady who was bringing this claim, hadn't given notice, the court found that that was sufficient notice. And the 11th Circuit Court found that that notice was enough to allow the suit to go forward. So the suit was allowed to go forward. So what's the point of this? The point of this is very simple. Under Title IX, if someone is concerned with sexual discrimination, they must give notice to the school authorities. If you don't give notice, you can't bring suit. This is a little bit of an unusual case in that notice was established through the acts against other people, people other than the person who was actually bringing suit. But it shows the way in which the court was willing to consider the overall set of circumstances and view the notice of other people as assisting the person who wanted to bring claim. The other thing that it demonstrates is that in U.S. law, notice is extremely important. I mean, even when you sue somebody, and the law doesn't require you to give them notice before you actually file a complaint in a court, when you serve them with that complaint, you must serve them. There must be evidence, we see that in the movies all the time, that that person that you're accusing of something was served, was given notice. Notice is the bedrock of basic procedure under the law. And in this instance, we see how in some instances there can be notice that is obtained when it doesn't involve the people that actually are bringing claim, but that's highly unusual, highly unusual. Okay, we wanted to bring you this case this week, so again, you are better informed as to how the law works so you can make the law work for you. I'm David Allen.